So we're continuing our conversation with Amna Shirazi, and we would like to move to immigration court proceedings. So if someone has been charged, we're assuming that they're not in detention, but someone has received a notice to appear before an immigration court, what is that like?
Well, a notice to appear is issued usually after someone has been picked up by ICE. In some cases, they're given to people at the time of application for admission at the airport. But basically what it is a charging document. In that notice to appear, whoever issued it, and it's typically ICE, will lay out the reasons that they feel that you are removable from the United States. This is obviously not an expedited removal situation, and we will discuss, I guess, that later. Yes. However, in a situation where a person is being removed from the United States, they are given a charging document basically explaining who they are, why they're being removed, and then the charge of removability. Now, ICE has the right, I've seen situations many times where ICE doesn't even file that with the court. There are NTAs that are issued that aren't specifically filed with the court, especially in today's current climate where immigration reform is looming. They do not want to tie up the resources of the courts by filing those NTAs and asking litigation to take over where someone might be a good candidate for reform down the line. So there are two situations. An NTA that's issued and filed with the court, in that case it goes into immigration court proceedings. There's a second situation where an NTA is filed and is never filed with the court, so a person is technically removable as charged, assuming that they admit and concede all of those things on the charging document, but it's never filed with the court, so they're not in removal proceedings.
And we have a chart shown on the slide here that provides pathways within immigration court, and it's very complicated.
Well, once the NTA is filed with the court, assuming ICE really wants to proceed with this person's removal, the first thing that assuming that the individual has an attorney, the first thing that an attorney would do is look at what their forms of relief from removal are. The first appearance in court is called a master calendar hearing, and that's really when a respondent would show up to immigration court, represented or not, and appear in front of the immigration judge for the first sort of calendar call, if you will, where you go to the court, admit and concede your charges or deny your charges. If you do admit them, you can explain what form of relief you have from removal, if you have any at all. And then at that stage, the judge determines whether or not you have a form of relief from removal or they think that you don't. If they think that you don't, they may go ahead and say, you have the option of voluntary departure, or I'm ordering you removed. If it's a voluntary departure order and the individual takes it, there's no appeal from that, and everyone goes on their merry way. If it's an order of deportation for whatever reason at that master level, then they have the right to appeal that decision. The other way that this could happen is at the master, there is a form of relief that's been identified. And so at that stage, the judge will set the case down for an individual hearing. And the court dockets at this stage vary from judge to judge. There are some judges, for example, right now that have hearings that are going into 2015. Other judges have cases that are in 2014. So these cases get set out pretty far out.
So an enormous backlog.
It is an enormous backlog.
And is part of that because most people who appear in immigration court are not represented by attorneys? Does that lengthen the process?
I don't think so, because in fact I think that those that are not represented oftentimes shorten the process because they're not able to identify forms of relief. And so oftentimes they're sort of talked into taking an order of removal or taking voluntary departure, given that sort of option from a sympathetic judge who's explaining their options to them. So I think that when you do have a legitimate claim to relief and you apply for it, that's when the wait times start. Because what that is, that individual hearing really is just that. It's an individual hearing, excuse me, where the respondent comes, hopefully with counsel, with their witnesses, and it's just you, the DOJ attorney, and the judge, a translator if needed, and basically you're allotted your 3 to 4 or 5 hours, whatever you need to give your evidence supporting your claim. and setting your record for your case.
All right, let's talk about the right to an attorney, which
Okay.
there is a right to an attorney, but it's only if you can afford one or if you have a volunteer attorney, and that's different from criminal court.
That's right. There is no right, actually, there's no right to representation in immigration court. You are allowed to have representation if you can afford to do so, or if you're lucky enough to be one of those few people that qualifies for indigent representation. There's just such a huge need for it that not everyone qualifies. All of the public service organizations are really struggling with funding right now. So it is true that many people end up going through this system, which has grave consequences on their life, on the lives of their kids, many of whom have been here 15, 17 years, and they're unrepresented. I find that to be pretty scary because of the ramifications on these people's lives, but the fact that they're going against very well-trained attorneys. I mean, they're Department of Justice lawyers. So even a regular bar attorney, is really got to brush up on their skill set to go up against one of these people.
Especially if they're not specialists who
That's
do
right.
this full time.
Yeah, these are good lawyers.
I read a New York Times article recently, and it's talking about the increasing number of minors, children, crossing the border with Mexico. And very often they are from Central America, and they have traveled through Mexico and have entered the United States, and then are picked up and are put into detention, deportation proceedings. Mm-hmm. They are, the article says only about half of them are represented by attorneys. So if that's a matter of concern generally for adults, it ought to be of particular concern, I think, where children are involved, because they have much less exposure to the world and would be very easily intimidated by the whole process, I would think.
That's absolutely true. We have seen a huge increase in juvenile border crossings, and not just from Mexico. I mean, they use the Mexican border, but it's a lot of children from Honduras, El Salvador, Guatemala, and they're coming over unaccompanied with the coyotes. And many of them come to family members here. We do have special juvenile proceedings in which it'll be an all-juvenile docket. They do try to release these kids from custody as soon as they can, especially if there's a family member. But oftentimes there's very little that you can do to preserve, a child who's just coming across the border, to preserve their ability to stay here. I have actually a lot of juvenile cases right now from Guatemala, and they're pretty interesting cases. In many cases, there's not much you can do. It is sympathetic when an 8-year-old is sitting there and you wonder how they got here by themselves, and what fear they must have faced, and just now having been put through the system, and in many cases their family members are afraid to come to court because they too are illegal. So it often makes me very I guess, aware of just the struggles that these kids' families must be facing to put their children into a situation like this, the responsibility that they're dealing with. So, at the end of the day, there's most of the time not much you can do for these kids except help them get back home safely. But the experiences they go through, the horror that I think that they probably have lived through to get here to begin with, in many cases I have to explain to them they have maybe 1 or 2 years and they're going to have to go home. And there's really not much you can do. There are exceptions, obviously. There are cases where a child might be able to apply for asylum, or maybe they were a victim of a crime or escaping some sort of torture from home, and you can maybe ask for asylum or something like that, but those are rare.
Well, that's a very quick overview of the immigration court system. We're going to turn next to detention.
The preceding program is copyrighted by Emory University.